portion of it and consequently writ appeal also not made. Now, I will also canvass, I'm also canvassing the writ appeal. I'm also canvassing the writ appeal is not maintained per se, because your lordship may kindly see the order, impugned order by the learned single judge. The learned single judge order at internal page 88 and 125, this one. Writ appeal papers. Learned single judge's order, the operative portion at page 125. There were 4 writ petitions filed by myself to the extent of 160 acres. The brothers of Kaveri, each of the brothers Kaveri in their subsequent purchases filed 2 writ petitions, challenged to the extent that they are entitled to 155. The Kempaya filed a writ petition seeking for a re-grant to the extent of 494 acres. So far as my writ petition was concerned, the writ petition was a note directing that authorities to make a re-grant in my name and consequently put the record. So far as the writ petitions of Kempaya and other 2 brothers of Kaveri Reddy was remanded to the tribunal for adjudication. Now I take your own lordship only to the operative portion of the RFP. Writ petition number 27,497 is allowed. That's my writ petition. And finding recorded by the Land Tribunal, Bangalore North Taluk, with the impugned order dated in the case is set aside. In respect of the claim made by the petitioner, Kemparaju, therefore the revenue authorities are directed to mutate the records in the name of legal representative of Kemparaju in respect of the land to an extent of 160 acres of the subject land of the suit. Now, this order has been challenged before this court. There is one more order against him. Your lordship, there is one more order against him. That is the writ petition in the para 3 of the order. Writ petition number 23-144 of 2007 is disposed of and matter is remitted to the Land Tribunal entirely for the fresh consideration in respect of the claim made by Kempaya, excluding the subject matter of land in original suit so and so, and in the light of observation made above. So his claim for 494 acres, then para 4, your lordship, the respondent Land Tribunal is directed to expedite the hearing and dispose of the matter at the earliest in respect of the remaining land left out after excluding the land to an extent of 160 acres of land. So there is 2 orders facing on entitlement of 160 acres of land in favor of him, disentitlement to him to the extent of 160 acres. Without challenging this order at page 4, para 4, he could not have made a writ petition challenging only the order against him. Now let us say, your lordship, now, why I am telling you, for example, your lordship said, allows the appeal. For argument's sake, let us say the appeal is allowed. The allowing of the appeal only disentitles me to have the 160 acres of land. It does not entitle him to have the land. He ought to have challenged the order passed against him, saying that the Land Tribunal shall adjudicate the land, his claim to the extent of claim made by excluding 160 acres of land. If 160 acres is excluded by the order, the tribunal is not competent to decide whether he is entitled to that 160 acres of land which has been granted to me. As such, the writ petition without challenging that portion of the see page 15, the brief facts of the case in the writ appeal. He confines this writ petition only to this writ petition. It's his statement. Para 6 of the writ appeal, your lordship may kindly see. Para 6 of the writ appeal, page 14. In page 14. Your lordship noted. Para 6 of the writ appeal at page 14, starts at page 14, the end of it. It is submitted there are various competing claims respect of the portions of the scheduled property by different parties, state petition, so on, so on, so. This writ appeal is being filed specifically challenging the findings made and judgment passed by the learned Shinji in the impugned judgment dated so 27,000. So he says that he is challenging only the order passed by in the writ petition number 27,409, not other findings. As such, he debarred to make one because since it's not been challenged, it has attained that order has attained finality. If that order has been attained finality, he can make this writ appeal. So on that score, also the writ appeal, he is not competent to file this writ appeal in view of he having not challenged, has to be considered this writ appeal is rejected. Now the next point that I would like to canvass is the scope of writ appeal, section 4. Section 3 considered. I'll take your own because the time is running out. I'll take your order. May I take your lordship statement to para 4? May I take your lordship statement to para 4 of the judgment? Para 4 of the judgment. A learned judge of the High Court cannot be regarded as a court subordinate to the High Court. A decision which has been taken, your lordship can be called out. There can be no gainsaying the portion of it is called out in the next paragraph. There can be no gainsaying that a learned single judge, while exercising the power of deciding a writ petition by virtue of allocate, does not sit as a subordinate court or judge subordinate to those who constitute the division bench. As the question of subordination does not arise at all, resultantly, the applicability of provisions of Order 41, Rule 23 to 26A is not attacked. Separate power is not curtailed in any way. Separate power is not curtailed in any way merely for the reason that a writ appeal is an intra-court appeal. But the fact that it is an intra-court appeal and it is in the nature of a second look, the subject matter requires, required by the appellate bench while considering. Now, your lordship can this is important. They take out, call out the decision. Yes, in the Lakshman case, your lordship can be the last 2 lines, the last 3 lines. We are sitting in an appeal against the decision of the learned single judge of this court, unless the said decision is established to be clearly wrong. We cannot interfere with the said decision just because it is shown to be not right. In Srimati Padma, it is observed that a court of appeal interferes not when the judgment and attack is not right, but only when it is shown to be wrong. So the judgment of the single judge has been emotionally classified into 3: right, not right, wrong. If it is wrong, the appellate court can interfere. If it falls within the gray area of right and not right, the court should not interfere. So the judgment impugned does not fall within the ambit of wrong. I will come to that later. Then the last authority that I am trying to proposition I canvass is